If there is any principle of the Constitution that more imperatively calls for attachment than any other, it is the principle of free thought. Not free thought for those who agree with us, but freedom for the thought we hate. Justice Holmes was certainly correct when he challenged us with this observation in U.S. v. Schwimmer. We must allow freedom for the thought that we hate, but when hateful thought risks hateful action, that expression must at some point be restricted. Although the First Amendment is written in absolute terms, reasonable time, place, and manner restrictions can be placed on the freedom of expression.
Most fundamentally, the right to freedom of speech must be limited whenever there is a serious threat to national security. The court ruled in Schenck v. United States that speech that would be tolerable in peacetime might not be allowed in wartime. The Supreme Court has clarified that the protection runs to both actual speech as well as to symbolic speech. But there are times when symbolic speech must also be limited, as seen in U.S. v. O'Brien, which held the burning of draft cards to be unconstitutional.
The speech of students may also be subject to greater restrictions. In Tinker v. Des Moines, the court held that even symbolic speech in schools could be limited if it distracts from the learning environment, yet it allowed it there.
The First Amendment protects other forms of expression, which likewise must at some times be limited. The court held in Employment Division v. Smith that religious expression may be limited when it involves illegal action. The right to assemble can also be limited, as seen as Madison v. Women's Health Center, when the court upheld the restrictions on the distance protesters must maintain from abortion clinics. Finally, freedom of the press can be limited in courtrooms, as seen in Shepard v. Maxwell.
In today's rapidly changing and diverse society, we believe that we must have separate standards for separate types of speech. The Supreme Court has created separate tests to determine when to limit different types of speech, such as the four-pronged test to limit commercial speech in Central Hudson Gas and Electric v. Public Service Commission, and the three-pronged test to limit obscenity in Miller v. California.
In terms of hate speech, we agree with the standards set in Brandenburg v. Ohio that speech that can lead to imminent lawless action should not be allowed. A chilling example is provided by the Rwandan genocide, when the radio was taken over by the Hutu majority who called for the extermination of the Tutsis. Hate speech of this caliber, broadcast over the entire nation and so blatantly calling for genocide, should never be allowed. We believe, therefore, that hate speech should be protected by the First Amendment, but when hate speech is likely to lead to hate crimes, it should lose its protection.
Freedom of expression has many benefits. The First Amendment provides for a free-flowing exchange of ideas between all Americans, who are, as James Madison wrote in Federalist 51, the fountain of authority. If one person does not agree with another's speech, they have the freedom to counter it with speech of their own. During the Civil Rights era, citizens used their expression to overcome oppression and foster equality for African Americans.
Yet freedom of expression also comes with a price. Oftentimes, the protections of the First Amendment can lead to psychological harm, as seen in cases like Brandenburg v. Ohio and National Socialist Party v. Village of Skokie. But even in the face of disturbing symbols, protection is extended, as in RV versus St. Paul, where the court protected the burning of a cross.
Certain forms of expression, like hate speech, more often than not cause tension and disunity among Americans. Yet we agree with the Supreme Court, which upheld the right in Texas v. Johnson to do something that many Americans find incredibly offensive, burning an American flag. We believe that the many benefits to freedom of expression outweigh the costs.
The First Amendment is an essential part of every American's life, even those whose expression is deemed offensive by the majority of society. Every American has the right to express his or her ideas, even the ideas that most believe are wrong. As Justice Lewis Powell wrote in Gertz v. Robert Welch, under the First Amendment, there is no such thing as a false idea. This concludes our statement, and we're now ready for your questions.